Hi, thanks so much for joining our webinar this morning. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is payment bond claims, the basics. So without further ado, I'd like to introduce the fabulous and wonderful Rebecca Hicks.
Good morning, everybody. We're here today to talk about one of my favorite subject matters, and that is payment bond claims. I am the type of nerd that actually likes payment bond claims. So my goal today is, as Jesse mentioned, I'm a construction lawyer. My practice is based in Dallas, Texas, but we handle cases all over the state of Texas. I'm board certified in construction law, and we spend a lot of our time perfecting and litigating bond claims and lien claims. So today we're only scheduled to be together for around 20 minutes. I cannot promise you we're going to end exactly on time, but we're going to try. That being said, you are not going to know everything there is to know about payment bond claims in the state of Texas in that amount of time. My goal is to give you a good introduction to what we're talking about, and for you to leave here at least knowing how do I get my payment, which projects are covered by a payment bond, and what's my deadline? What are my deadlines? So that's kind of my goal today. So that being said, here are the key questions that you're going to need to know about any job that you're working on to determine how you're going to make a claim. You're going to need to know the correct name and location of the project, who's the owner, because you've got to be able to tell whether it's private, state, local government, or federal government. You're going to need to know what your position is in that construction chain, and you're going to need to know that last one, the one we're focusing in on there today, is there a payment bond? So we're not going to be talking about lien claims, which are predominantly how you're going to perfect your rights on privately owned projects. Today we're going to be talking about bonded jobs. So what do I mean? These are the four types of jobs that you can possibly have that make a difference in how you perfect your claim in Texas. You can have a private project, state or local government project, or a federal project, or public-private partnership, or P3. So what do we mean private project? Private project, we just mean any job that's owned by somebody that's not a governmental entity. If it's owned by individuals, that's a private project. If it's owned by a corporation, that's a private project. And what do I mean owned? I mean when you look at the deed for the property, not the CAD record, but the deed, who is on the deed? What's the name on that deed? Who owns that property? Ownership of property is governed by who's on the deed. Some people often get tangled up and make mistakes relying on just CAD records. Just word of caution, CAD records can be up to a year out of date. Why? The Central Appraisal District, CAD, only needs to tax once a year. They're sometimes not as diligent as they should be in updating their online records. That is not how ownership of the property is determined. That's just for the tax assessor. Those records aren't there for you to determine ownership. So you want to be looking at deed records for ownership. So a private project is anything that's privately owned. So then what are we talking about? Private projects can be bonded. Private projects do not have to be bonded. Most of them are not bonded, meaning there's no payment bond on most private projects, but any private project can be bonded under Chapter 53 of the Texas Property Code. So when you're doing your project research, you're always going to ask, even if it's a private job, is there a payment bond on this job? So the next type of project could be state, local government, or municipalities. These types of jobs will be bonded. They are required to be bonded by Chapter 2253 of the Texas Government Code. So the government should require whoever the general contractor is on that job to put up a payment bond. Anytime you're working on public schools, fire stations, any tech dot jobs, anything that is state or local government, there will be a payment bond, and so you should be focused on getting a copy of the payment bond up front in your project research. So then federal jobs, if it's federal, say you're doing work on a post office, maybe it's on a military base. Those types of federal projects also must have a payment bond. So these jobs will always be bonded. So you again would focus on trying to get a copy of the payment bond. So then public-private partnerships, these are becoming more and more common. They kind of confuse people, but for our perspective today, public-private partnerships are treated just like local government jobs in Texas. That means Chapter 2253, there will be a bond. There will be a bond on anything that is a public-private partnership. So if you find yourself working on one of those, ask for the payment bond. So you got to figure out, for the private project specifically, you're going to have to determine if it's bonded or not. If it's state or local government or federal job, you know, there's a payment bond, I need to get a copy of it. But if it's a private job, you're going to have to ask the question, because there's no magic way that you're going to be able to tell whether the job is bonded or not without asking the general contractor or asking the owner if the job is bonded and getting a copy of that payment bond. So let's just kind of take a step back, and so we all understand, okay, I've been saying a lot about payment bonds and which jobs should be bonded or will be bonded or might be bonded, but what's a payment bond? A payment bond is just simply, it's the equivalent of an insurance policy that is purchased by the general contractor on a job. The insurance company is the surety, and what that payment bond says, it says, hey, owner, if I, as the general contractor, do not pay my suppliers or subcontractors on your job, here is this insurance policy or this payment bond that'll pay them in my stead. Your property is not going to be lien. These claims aren't going to be coming to you, owner, because here's the insurance policy that's going to pay my subcontractors and suppliers if I do not pay them. That's generally speaking what a payment bond is. So let's talk about some gotcha types of bonds, because there's several different types of bonds that flow around on these construction projects. One of them you often get a performance bond and a payment bond at the same time. If you request from the owner or the general contractor, hey, can you send me a copy of the payment bond on this project, they're probably going to email you a PDF that has the bond. If you look, a lot of times what they do is they just lump the performance bond and the payment bond together. For purposes of you perfecting a claim because you haven't been paid on a job, you don't care about the performance bond. You care about the payment bond. How are you going to be able to tell the difference? You're going to look at the top of the bond and it will say at the top either performance bond or payment bond. If it says performance bond and you do not scroll through and find any of the pages that say payment bond, they have sent you the wrong bond. So look for the one that says payment bond, but just oftentimes these bonds are issued together. In fact, most of the time they are. The performance bond and the payment bond are issued at the same time. And so they get filed in the same file. And when you make the request, oftentimes they send you both. If they send you both, just be sure you're focused on making your claim referring to the payment bond, not the performance bond. Oftentimes the bond number is different between the two bonds, so just make sure you're looking at the same bond. What is a performance bond? Just so you kind of have a big picture view. Performance bond, the reason why I'm saying that does not apply to you is because what the performance bond is a separate type of insurance, basically insurance policy procured by the general contractor that is a guarantee to the owner that, hey, owner, if I as general contractor do not complete your job, if I for some reason default and just stop performance, here is this bond over here that where the surety, this insurance company surety, is guaranteeing you, owner, that they will take over in my stead and finish your job. So that the performance bond is to protect the owner in the situation where the general contractor doesn't perform for some reason. You're focused on the payment bond because that's the one where the general contractor is promising to pay its subs and suppliers. Here's another type of payment bond that can kind of throw things off, but you definitely want to know about this but subcontractor payment bonds. For government jobs, we've talked about the bond we're looking for. The bond we're normally going to see on these projects is the payment bond issued where the general contractor is the principal on the bond. But more and more jobs are requiring payment bonds, but subcontractor payment bonds. So if it's a subcontractor payment bond, what you're going to see is the principal on the bond will be the subcontractor, not the general contractor. What does that mean? That means there'll be two bonds on that job you need to know about. There would be a bond that is where the subcontractor is the principal, and then there's going to be a bond where the general contractor is the principal. And you want to know about both of those bonds so that you can make a claim on both bonds. So, okay, so we talked about these jobs where there could be a bond, there should be a bond, there will be a bond. How do you get a copy of the bond? My advice is to, when you first start working on the job, before there are any issues, and I know this is harder to do than it is for me to say, but best practice is always try to get the bond up front. And ideally what you want to do is get an actual copy of the payment bond rather than just having someone write out the bond number or the bond information. You would not, one of the things that I've learned over 20-something years of practicing construction law is that when we get these job information sheets that kind of have the bond information written in by the customer or written in by somebody else, they get it wrong a lot of the time. And so you want to get a copy of the payment bond so that you can ensure that you have 100% correct bonding information. Because what did I say? Sureties who issue these payment bonds are insurance companies. What are insurance companies in the business of? They're generally in the business of denying claims. If you make a technical error in your bond claim, meaning you get the wrong bond number, you send it to the wrong surety because that's what was in the job sheet, but that's not what the actual bond says, your claim's going to get denied. So you want to make sure that best practice is to get a copy of the bond and get it up front. How are you going to do that? We oftentimes, when we get a file in, we just start calling the general contractor owner. Most of the time, there's no problem at all for them to just email a copy of that payment bond. Any sort of sophisticated general contractor or owner understands that payment bond is there for the benefit of those subcontractors or suppliers. They have no problem just sending that to you if your company is supplying material to the project or if you're doing work on the project. So just ask. Sometimes on private projects, you can actually find the payment bonds recorded in the real property records. So make sure that you know how to look on the real property records and just see if the payment bond is there. Your customer may have a copy of the payment bond. Never hurts to ask. If it is a government job, you may need to make a Freedom of Information Act request to get a copy of the bond. But note, sometimes it takes the government a while to respond to that, so you'd need to make that request early, long before any bond claim deadline. So one easy way to get these government payment bonds is to just make a Freedom of Information Act request. There's no real magic to making one of these. You'll be able to figure out whichever governmental entity owns the job, whatever their mechanism is for making a Freedom of Information Act request. It's usually some pretty simple online form that you fill out, and you just give them the information you have about the job and ask for a copy of the payment bond on the job. And normally, when we make these requests, we can usually get a turnaround of probably 2 weeks. So you can understand you are going to need to make that long before any bond claim deadline, but it is a good way to get a copy of the payment bond on these government jobs. Obviously, if it's a private project, there's no Freedom of Information requirement, so you're not going to be able to do that on a private project. And to find out how you do this, honestly, it's just Google. Google is your friend. There's no magic to how to make these Freedom of Information Act requests, and you as a supplier or subcontractor are definitely entitled to receive that information. So if you ask, they're most likely just going to send it to you. Some are faster than others. So here is the most important part of this seminar is we're going to be talking about the deadlines for the different types of bond claims. You're not going to know the niceties about how to perfect every single little issue on a bond claim in 20 minutes today. But if you walk out of here with a deadline so that you can get with somebody and get it taken care of in time, that's a win. So here are the deadlines that you have to meet for a private project bond claim. What does that mean? That means we're talking about a job that's owned by an individual, corporation, private, there's no government ownership. The deadlines for private project bond claims are the same as private project lien claims. You've got to send the notice on the 15th day of the third month, and then the extra step of actually filing the mechanics lien. But here's the confusing part. For private project payment bond claims, all that Chapter 53 of the Texas Property Code says about how you perfect that claim is that you need to send notice as you normally would for a mechanics lien claim, so that 15th day of the third month notice, and we now have a statutory form in Texas that you're using. So the legislature told us exactly what that needs to say and exactly what it needs to look like. Don't change anything, nothing, use their form. If you need to send that notice, but you need to send it to everyone in the construction chain, but add the surety. So let me say that one more time. To perfect a bond claim on a private project, you need to send the same notice form that you would send for a 15th day of the third month notice for a mechanics lien. You send it to all the same parties, meaning GC, owner, etc., but you also add the surety to your letter. That is your bond claim. According to Chapter 53 of the Texas Property Code, that notice letter is your bond claim. But normally the way my firm does it, because law firms, let's face it, we are risk adverse and we want to make darn sure that everybody knows about the claim, and we want to take every step we can to get you paid promptly. We also normally just go ahead and perfect the mechanics lien as well and send the surety a copy of the mechanics lien also. So those are the steps. So you're going to be sending that notice on the 15th day of the third month and including the surety, and you're going to be filing that mechanics lien by the 15th day of the fourth month from the last month that you did work on the project or supplied material to that project. Those are those deadlines. So you send the notice required to perfect the lien, add the surety to the notice letter, and you don't have to file a lien, but my recommendation is you do it anyways and send a copy to the surety. Who gets these notice letter? Who gets the notice letter? I get this question a lot, so I just want to make sure we're all on the same page when I'm talking about sending out this 15th day of the third month letter. Whoever you contracted with for sure needs to receive the letter. What address are you going to send it to? There might be a notice address in your contract. If there's a notice address in your contract with whomever, if you contracted with a general contractor, a lot of times that really, 40-page contract they got you to sign has a notice provision. You need to send the letter to the address on the notice provision. You would also send it to the registered agent for that company. Where are you going to find that information? You're going to find the registered agent on the Texas Secretary of State website. We have a great, pretty robust information available on the Texas Secretary of State website. It's called Texas SOS Direct. If you don't know how to find that information, look it up. It is a subscription paid service. You pay by the search, but the search is maybe $1, $2. It's just minimal amount of money for the information that you can get there. You want to make sure the notice letter is going to the general contractor. Again, you want to send that to their principal place of business and the registered agent on file with the Texas Secretary of State. If you are a second tier sub, you want to make sure that notice letter is going to the first tier subcontractor that you contracted with. And if for these bonded jobs, you've got to make sure that letter is going to the surety as well. For the surety, what you're looking for, you remember our best practice is we've got a copy of that payment bond. We got it up front and we can look at it and see, is there a notice address in the payment bond? So when you're looking at that payment bond, if there's a notice address, you need to be darn sure your notice letter goes to the notice address in the payment bond. Some payment bonds have a notice address, some don't. You also want to send that bond claim to the surety at the registered agent office identified in the Texas Department of Insurance website. So this isn't the Texas Secretary of State, it's the Texas Department of Insurance. That's where these sureties have to have a registered agent so that all of us know where to send a claim. You need to send the claim to the registered agent on file with the Texas Department of Insurance for that particular surety. How do you perfect a bond? You remember we talked about one of those additional types of bonds you may find on jobs, which is a subcontractor bond. That's the bond that's where the subcontractor is the principal on the bond rather than the general contractor. And what you're seeing is more and more general contractors are requiring at least their major subs on larger jobs to put up payment bonds because they want to push that risk down to the first tier major subs, right? So if you find yourself in a situation where there's two bonds, there's one from the general contractor and one from the subcontractor, how do you perfect your claim on the subcontractor bond? Subcontractor bonds are not covered in any of the Texas statutes that we're talking about today or the federal statutes. So the bond is just governed by what it says. You've got to read the bond and do what it says. If it has a particular deadline for getting the notice out, you need to meet the deadline in the bond. If it has particular information that you've got to provide that information as per the terms of the bond. So you just have to read the bond and comply with what it says because it's not a statutory type of bond. A lot of times you'll see these subcontractor bonds be limited to labor only or things like that because it's not governed by the statute. So whatever, just read what the bond says and make the claim. Now let's talk about those state and local government jobs. And again, this is the important part right here. This is the meat and potatoes of this presentation. These are your deadlines. You're working on, let's say, a TxDOT job. And so it is a bonded job under Chapter 2253 of the Texas Government Code. What are my deadlines? These deadlines come faster. You've got to send a notice, a preliminary notice out by the 15th day of the second month. The 15th day of the second month after each month that you provide material or provide labor to the job. So that's going to come up quick. If you've got invoices that are knocking on 60 days, you could be looking at a deadline to get that preliminary notice out 15th day of the second month. So this one, if you're working on those government jobs, just be prepared to act quickly if you're not getting paid. And it's a double-edged sword because we all know the government pays slow. And so if you're in a contingent payment situation or pay if paid situation, that money might not be coming to you because the general contractor just hasn't been paid yet. We all understand that. This deadline does not wait. These deadlines run from the date that you perform labor or materials on the job. They run from each month. So if you haven't been here, if you haven't been paid for work that you did in January, that notice letter has to go out on or before March 15th. If it does not go out on or before March 15th, you're dead in the water on any bond claim. So on these state or local government jobs, just be prepared to act quickly and know that, yeah, even if you're under a contingent payment clause in a contract, you still need to make the claim. And these, any sort of general contractor and specifically the owners on these, the government owners are very attuned to, they know these notice letters have to go out. It's statutory. They shouldn't get upset about getting the notice letter because you have to send it or you lose your rights. Then to make the actual bond claim, you have to send a separate bond claim letter by the 15th day of the third month after each month that you performed labor or provided materials that have not been paid for. That's different than what we talked about for the deadline on a mechanics lien, because a mechanics lien, you only ever need to make one mechanics lien. You file the mechanics lien at the end of your involvement on that project. You file it by the 15th day of the fourth month. Here, it doesn't work that way. you have to file it by the 50th day. You have to send, and this is, I'm sorry, I shouldn't be saying file. You have to mail the payment bond claim by the 15th day of the 3rd month after each month. So you may have to make, if you're continuing to work on a job and haven't been paid for several months, you may have to make more than one bond claim. The 2nd month notice still applies for these state and local government jobs, so just be aware of that. It's going to come up quick. You've got to send that preliminary notice letter, and then you've got to send the bond claim 15th day of the 3rd month. So that preliminary notice is going to, the preliminary notice on these state and local government jobs really only has to go to the general contractor. Best practice is to send that preliminary notice to everybody above you in the construction chain. You don't have to send it to the governmental entity. The governmental entity is never going to be liable. You can copy them on your letter if you want to, but they're never going to be liable for a bond claim or for payment to your company. If you think it'll twig them and let them know that you're still out there not paid, do it. But generally speaking, you want that, it's only the preliminary notice 15th day of the 2nd month on a state or local government job only has to go to the general contractor, but we generally send it to everybody in the construction chain above you. And here's just kind of an example of what we use as our preliminary notice letter. There's no magic to it. You just got to give that general contractor notice that, hey, you're out there and you haven't been paid. We also include this request for information that is allowed by Chapter 2253. You'll see over there the numbered list asking for information. We include that just because why not? You're sending a letter anyways. Why not go ahead and ask for the information to see if you can get that? But there's no real magic to these preliminary notices. And SunRay can take care of these notices for you if you want to outsource it to one of these companies. That's one of the things that SunRay's in the business of doing. Then that 2nd notice, the 15th day of the 3rd month, is your actual quote unquote bond claim, right? So there's some magic language that needs to be in that bond claim. You're going to need a sworn statement of account stating that the amount claimed is just and correct, and that all just and lawful offsets, payments, and credits to the FET have been allowed. That magic language I've got there on the screen is 100% directly from Chapter 2253 of the government code, Texas government code. So you just want to make sure that's in your sworn statement. A sworn statement is basically the equivalent of an affidavit. So it's a statement of fact that is signed by somebody with knowledge, and you have to sign it and swear to it before a notary. So it's a notarized document that you have to get out the door. In addition to usually we'll send it with a cover letter. So there's a cover letter and a sworn statement that would make up your Chapter 2253 bond claim. And here, let's look. And so who does this notice letter go to? Your bond claim notice letter and sworn statement of account goes to, again, everybody above you in the construction chain, including the surety. So you're going to be sending it to the first, if you're a 2nd tier sub, it goes to the 1st tier sub, the general contractor, and the surety as well, to those addresses that we talked about before as to who gets the notice letter. And here's just an example of our bond claim cover letter. So this is the letter that will go with the sworn statement that says, hey, we're making a bond claim under Chapter 2253 of the Texas Government Code. We're enclosing with this a sworn statement that meets all those requirements for the statute. Thank you very much. That's the basics of it, right? And then here's an example of what I mean by a sworn statement. Here's an example of what I mean by the sworn statement. It's just a statement of it's a statement providing all of the information required by Texas Government Code Chapter 2253 to meet all those statutory requirements so that you have what you need to make a claim against the surety. So hopefully they'll get you paid. One of the biggest mistakes we see, most often on bond claims that we get from clients where they try to do it themselves, those types of things, is they just get the addresses wrong. So word of caution, be careful when you're getting those addresses. The hardest part of these notice letters is getting the addresses correct, getting that notice address for the surety 100% correct, getting your addresses for the general contractor, etc., 100% correct. You want to make sure that you're using those registered agent addresses that you're going to find on the Texas Secretary of State for those notice letters. You want to make sure you're following exactly what's on the payment bond on these claims. So you're going to want, if you look at these letters, basically it's referencing the payment bond number in the RE section. You're referencing that so that the surety knows who needs to get this claim, where does it belong, what payment bond are you making a claim on. So you want to make sure that information is 100% correct, and it's very detail oriented. So most of the time when we see mistakes in this stuff, it's just because someone just wasn't paying attention to detail. The best practice on these bond claims is also to attach the copies of the invoices that are unpaid, or if you're doing pay applications, copies of the unpaid pay applications to the claim, because that helps document your claim to the surety. If you don't attach to the initial letter, they're going to ask for it anyways. There's a specific section of Chapter 2253 that I just want to kind of make you aware of that has to do with unit price contracts. Unit price and the statute does not define what a unit price contract is. There's really very little Texas law on what a unit price contract is. But if you are selling a product by, let's say, the linear foot, or you're selling it by the ton, that is most likely going to be considered a unit price contract. So you will need to include some additional language in your sworn statement of account on a Chapter 2253 claim to account for the unit price contract terms. We do it as an abundance of caution for our clients that do equipment rental, because equipment rental is generally going to be rented by the week or the hour, or there's going to be some price per time, per unit of time. Or, you know, if they're selling lumber, lumber is usually sold by the linear foot. That might be considered a unit price contract. So we just put that language in there to be safe. So now let's talk about the limitations period. What does that mean? Once you've made the bond claim, either on a private project or a Chapter 2253 project, the deadline for, if the surety for some reason does not pay that claim, you have 1 year to file a lawsuit. So keep that in mind. We always think, they'll pay me in a year, but a year can go by really quick. So just make sure once you make these claims, you really are keeping track of when that deadline is to file a lawsuit. And once you get to that phase, you will not be able to do it yourself. You would have to hire an attorney to file suit against the surety. And for these lawsuits, you would generally file a suit against whomever you contracted with, because they haven't paid you, obviously, and also against the surety on the payment bond claim is normally how it would work. Now, let's talk about Miller Act claims. This is federal projects. So if any of you are doing federal work, listen up. And it's good news, because federal bond claims are a lot easier than state bond claims. The deadline's longer and the claim form is easier. All you've got to do is one notice 90 days after the last furnishing of labor or materials. That's it. That's the only requirement on a federal claim. So if you're working on post office, you're working on a military base, that's your deadline. That goes out 90 days after the last furnishing. It's when it's got to go out. Right. Downside on these federal projects, if you are second tier or below, you're not protected. So that in that case, what you would need to do is make sure the party above you in the construction chain has perfected their bond claim, including money owed to you. They just, at the federal level, they cut off liability. So keep that in mind on these federal jobs. And here's just an example of what that 90-day letter looks like on a federal job. It's very simple. Hey, we haven't been paid. We did the work. This is our claim. So these federal jobs are a lot easier. The deadline's longer, and the notice is easier. And again, on a federal job, if you happen to make one of those bond claims, that deadline to actually file a lawsuit against the surety if they haven't paid your claim is that 1 year. Now let's talk about once you've made the bond claim, what can you expect from the surety? As soon as you send a letter to a surety making a bond claim, you're going to get back a form letter that says, hey, we got your letter. We need a lot more information to verify your claim. And they'll generally have a laundry list asking you for all kinds of documentation to back up your claim, delivery tickets, copies of the invoices, your contract, copies of checks for payments. And sometimes they'll ask you to fill out another form that they call a sworn statement to verify the claim. So when you get that letter from the surety, it's a standard form letter. Just provide them what they ask for. Even if you've already provided part of that information with your initial letter, my advice is just to do it again. You want to overkill it, give the surety what they want so that they can say yes and pay your claim. If the surety does not pay, that's when you have to go ahead and file the lawsuit. You have to do, and safe rule of thumb for all of these is don't let it get a year old. File the lawsuit long before a year passes from the date you mailed that claim. And that's really all of the planned comments I have for today. I'm happy to answer any questions.
Well, first of all, you were incredible as always and as expected. So thank you so much for that. We do have a couple of questions that came through. The first one, it says, do all bonds have to be recorded? I believe you've already gone through this, but
No, they
go ahead and
don't.
answer it as well.
They do
Okay,
not.
perfect.
Especially on these government jobs, they're not going to be recorded most of the time.
Yep.
Private projects, they can be recorded, but they don't have to be.
Okay. And then it says the normal preliminary notice on an unbonded job is a 3rd-month fund trapping notice. On a bonded job, is it a different document?
No, that is 100% exactly the same document, but you're going to add the surety up where you're putting your addresses into your fund trapping notice letter, which is that statutory form. You're just adding the surety to that letter.
Perfect. Okay, and then this one says, what if a bond is not recorded and they don't provide the bond? Is there something you can send that they must respond to? You've already covered this. They would have to send the Freedom of Information Act request. Is there anything that any other things that you could add to that potentially, Rebecca?
Yes, there is actually a section of Chapter 53. So, our Chapter 53 of the Texas Property Code, which governs our private projects. There's a section that says you can send a letter by certified mail to the general contractor and owner asking for the bond information. And then it says they have to respond to that within 10 days. If you're doing things at the last minute, that's not going to work, right? Because if you're about to be at that 15th day deadline, you don't have that kind of time to wait 10 days for them to respond. So there is a section that says if you send the letter, you need to send it certified mail, that they do need to respond and provide you that information. We don't end up using it that much in our office simply because A, we normally don't get the claims 10 days in advance. I wish we did. But B, if the owner or general contractor do not respond, and sometimes they just blow off that letter, quite frankly, there's no teeth to the statute. There's no real enforcement mechanism. If they don't do it, the only thing the statute says is that you can recover your cost of obtaining the bond in whatever other way. Well, there really is no other way other than you making phone calls, beating the pavement, finding the bond yourself. And so how do you make that claim? And they know that, sophisticated owners or general contractors know that. So sometimes if you send the letter, will they send the bond? Yeah. If they're acting in good faith, the good GCs, the real experienced ones will send it, but they'll generally send it just as well by you making a phone call or sending an email and just asking for it rather than having to send a formal letter by certified mail. So we normally get most of the bonds through informal means, but there is that formal provision in Chapter 53 of the Texas Property Code that you can use if you need to. And sure, that's a tool that you can have in your tool belt. For federal jobs, or I'm sorry, for government jobs, state, local government jobs, Chapter 2253. There's a similar provision in the Texas Government Code, Chapter 2253, that again says, allows you to request that bond information. It again gives them, I think it's still a 10-day period to respond, but most of the time on those you will get a response. But now, a lot of times you'll get confused government employees who think you need to go through the Freedom of Information Act request process. That's why my recommendation is just do it, because if they receive this letter asking for the bond, what we've experienced is you'll get a confused government employee that says, well, you need to make a Freedom of Information Act request, even though you just made your request under the statutory provision that says you can make the request. They still want you to go through this other process. So my advice is to, if you're going to use that format under Chapter 2253, sending the certified letter to ask for the information, that you just also do the Freedom of Information Act request as well.
All
I
right,
hope that answers the question.
Thank you so much for that. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions as soon as I can. Can you go to the next slide for us, please? Pardon me. Sorry, I had a tickle in my throat. All right, so these are some of the SunRay resources that we can give and provide to you to help you stay organized, know your deadline, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There are project information sheets on here. Rebecca kind of touched on them a little bit, and it will help kind of go through and ask the pertinent information when it does come down to a bond. If you do find out the job is bonded, yes, absolutely write down the bond number, but if you can get your hands on that actual bond, the physical copy of it, that is really, really helpful. It's nice to have that information early on in your project before there's any kind of a payment dispute, so that way you know kind of what the steps to your project would be moving forward. But check that out. Check out all the different resources that we have available to you. All right, and then the next slide, if you don't mind, please. All right, if you don't mind, take a moment to review us on Google. We really do appreciate your feedback. It helps us learn about what other topics you want us to potentially cover, and it helps to get the information out to other contractors and suppliers like yourselves. And then the last slide, please. All right, and with that, that's all we have for you today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Thank you again, Rebecca. You really are a gem. You're incredible, so thank you. And I hope you all have a wonderful and beautiful sunny day. Thanks, everyone.